You should always get a proffer letter before you cooperate with the government. I'm sure you've heard of a proffer letter or a queen for a day. So this is a letter that the U.S. Attorney presents to the defense prior to any kind of a cooperation meeting. This is a standard form letter. It may be written a little bit differently in different districts, but essentially what it says is that your attorney has told us that you wish to meet with us for the purposes of cooperating. It doesn't mean they're going to accept your cooperation. It just says you wanted to meet and talk about maybe what you know. The most important thing about the letter is where it says that you must be completely truthful. If they feel at any point that you are not being truthful, they can end the meeting and they can use your statements against you. They will know everything about your case by the time you're having this meeting. They have cell phone records, they have text messages, they have emails, they have bank accounts, they have spoken with witnesses. They have way more than you think they do, and they in fact may even know more about the case than you do. So you have to be completely honest with them. They will ask you questions that they know the answers to just to make sure that you're being honest with them. So that is the number one most important thing, and the U.S. Attorney will tell you that at the beginning of the meeting, even though your lawyers hopefully already hammered this into your head, that you can't hold back, you have to be completely honest with them. The next thing it says in the letter is that your statements given during this meeting will not be used against you in your case in chief. Well, chances are if you're having a cooperation meeting with the feds, you're not going to trial, so there isn't going to be a case in chief. A case in chief is the government's case against you in trial. So they can't use your statements. If you say at some point, you know what, I'm not going to do this, I want to fight my case, they can use those statements against you at that point. They will tell you, though, that they can use your statement to pursue leads. So if you tell them, I buried the body over there, they can use it to pursue leads. They can go and dig up the body. Now, they can't use your statement against you at trial, but they can use the DNA that they find or match the weapon that they found with the injuries, things like that. They can pursue leads, and they may lead back to you for other crimes that you may have committed. Chances are that's not going to happen. Most of the time, cooperation agreements go smoothly and everything is fine and it doesn't lead to new charges. So the only part of the proffer letter that everybody gets upset about is that no promises are made in the proffer letter. No promises are made during the meeting. No discussions of plea negotiations occur during the meeting. They will not guarantee, and it is in their sole discretion, the government's sole discretion, if they feel that you have provided substantial assistance in the prosecution of another, not against yourself, but against another, if it has to be information they don't already have. It's not that you're just confirming what they already know. It's new information, or you're really helping them put the puzzle pieces together that they couldn't figure out. That could be considered substantial assistance. So that's what the proffer letter says. It says you've discussed every part of the letter with your attorney, you sign it, your attorney signs it, and the U.S. Attorney signs it, and then the meeting begins, and you have this conversation that can last hours, depending on the number of questions and how well you are prepared to answer those questions. And there can be multiple meetings, and you can have the U.S. Attorney write another letter for each meeting, or have them confirm that that letter will apply to any and all meetings. And then cooperation information is defined as any information that they've obtained during your cooperation. Now, a proffer letter only goes to the statements that you make. If your cooperation involves active cooperation, like wearing a wire or engaging in transactions with somebody who's under investigation, that is not cooperation information because you're not telling them anything. You're doing things, you're acting. So the proffer letter is a very important part because you want to be sure, it's called use immunity, that they can't use your statements against you in the prosecution of you in your case. And that is proffer letters.